Hello everyone, my name is Adiola Kolawole of Los NG. So we want to continue with our April law series, which the main focus is on tenancy matters. So today we're going to be talking about, as earlier mentioned in previous videos, on the fact that tenancy agreement is very, very, very important. Like it's very important because it provides for, it has a lot of provisions that just protect either the, it can be the landlord or the tenant, and protect both parties. Now, so one of the provision of tenancy law, I know, and I mentioned earlier that I was going to be using tenancy law Lagos State as a reference for the generality of other laws, because most of these provisions are similar. Now, he said that where there is no stipulation as to the notice to be given by either party determining tenancy. So what are they saying is that if eventually you have a tenancy agreement and it wasn't stipulated how the term means end in the tenancy contest, to determine something means to end, to put an end to the tenancy. So if there's no stipulation as to how you want to determine tenancy, this would apply in the tenancy law. But if you already have, so for example, your landlord gives you a tenancy agreement and states that if you do not pay, maybe after 6 months or after a certain period of time, you'll be given a 3-month notice, even as a yearly tenant, or you'll be given a month notice, even as a yearly tenant, and you read that, signed, that's what will apply when it's time to get a notice. That you won't therefore come back and say, no, this is what the law says. The law says I'm a yearly tenant, so I'm entitled to a 6-month notice. No, because you saw it in the first place. If you had wanted to disagree with the landlord, you ought to have complained at that time that, no, why not give me something? Why not give me more time, before you signed the document? But if you after you signed, there's no room for complaint. So why are we saying that if it is otherwise you don't have provisions for same thing apply, even if it's a month notice that is there and you sign? But I realize that many times that this notice, the tenants probably have not even, they didn't even read that part. So it's when the decisions happen, it comes done, like the lawyer or part of the landlord will now write to you, and I'm like, where is this coming from? And they refer back to the tenancy agreement that, okay, this has actually been provided for in the agreement. So, but if not stated at all in the tenancy agreement, then what would apply would be a week notice for a tenant at will. So I'm going to explain tenant at will subsequently. So a month notice for a monthly tenant, a 3-month notice for a quarterly tenant. So sometimes the landlord can decide to collect monthly rent from you every 3 months. Same 3 months apply to someone that pays every 6 months, and 6-month notice for a yearly tenant. So that's it. But this would not apply if it's otherwise stated, if you have provisions in your tenancy agreement that provides for how your tenancy will be determined. Then another thing, and I also noticed the fact that in your tenancy agreement, it's also possible that it's stated in there that you are a fixed tenant, which will be determined, that means end, as I said earlier, by efflution of time. That means by the time that the time ends. So for example, your tenancy starts January 1st, 2021, and so that means it ends by the end of the year, which is December 31, 2021. It's a whole year. Now, and your tenancy agreement says you're a fixed tenant, which you determine by the efflution of time. So by December 31st, 2021, tenancy have ended, and so there's no longer tenancy. So the law provides that if your landlord decides that he wants you to leave, you're not entitled to a 6-month notice. You're only entitled to a 7 days landlord's entitled to recover possession. So landlord can take up with it. So landlord don't need to give you any notice because it's determined. So let me read the part of it that's in the law. And so it says that in case of a tenancy for a fixed term, no notice to quit shall be required once the tenant has been determined by the inflation of time. And when the landlord intends to proceed to court to recover possession, it shall only serve that tenant a 7-day notice. That's all that you are entitled to. But you know what happens when we get a tenancy agreement at first and it ends, and then you pay another 1 year. The landlord receives the rent, you pay another 1 year. So that automatically puts you on a yearly tenant basis, and so it's no longer going to be that it's a fixed tenant, except the landlord gives another tenancy agreement that it keeps giving you every year. But I believe that by the time you keep paying yearly without the renewal of the tenancy agreement, so you keep paying, you pay the same rent, 500,000, pay the same rent for 3-4 years, you're already in that category of a tenancy, a yearly tenant, and so it's no longer going to be like you're a fixed tenant. That's how I can interpret the law firm. So, but if a new agreement was given to you, maybe an updated one by the landlord, that okay, this is the tenant for this particular tenancy period, and another one for the tenancy period, that can be called a fixed tenant. But if you're paying every year, you renewed the rent, and landlord collected it, and keep renewing, I don't think the landlord will come and state that you are a fixed tenant. So the same thing applies to in case of a quarterly or half yearly tenant. So now let me come back to another aspect that happens that landlords and tenants always argue about, and that's the issue of so I'm going to use it as an example. So as a landlord, you have a tenant that has been owing you as a yearly tenant, he's been owing you for a year. He's been owing you for a year, or owing you for 2 years. That means he's in arrears of his rent. Now, the law says, because I know tenants will come and say the landlord did not give me adequate notice. What the law provides is that you're only entitled to 7 days, because I'm going to state it so that you know that it's provided for in the law. So it says that in case of a monthly tenancy where the tenant is already in arrears of rent for 6 months, the tenancy shall lapse, and the court shall make order for possession and arrears of rent upon proof of that. Same thing applies to quarterly or half-yearly tenancy, where the tenant is in arrears of 1 year's rent. The tenancy shall automatically lapse, and so the court shall make an order for possession as well. So we see that. So if you're owing so I believe that for a yearly tenant, if tenancy is already in arrears of above 2 years, you don't expect it has automatically ended, it has lapsed, and so you're not entitled to any 6-month notice. The court can make an order for possession as it requires, as it requires. Okay, then lastly on this particular one is, so in the old law, in the rent control, there was this thing that was ongoing, that your rent has to expire on the anniversary of your tenancy, but that's no longer applicable. So most of the time back then in the rent control, whenever they want to issue a notice to quit, they have to now calculate so well that it must not exceed. So for example, your rent is January 1 and you want to give someone notice December 31st of that year. So you would have calculated it that it must be exactly 6 months. It must end on the anniversary, that is 31st. Anything that above that, it more like makes the notice invalid, like that. But that's no longer applicable. And so, for example, a landlord wants to give a tenant notice to quit, and maybe the thought came, and there's no provision for a tenancy agreement, or there's even tenancy agreement at all. And so fall back to the law, because the person has been paying yearly, so the person yearly tenant wants to give 6 month notice. And if he just thought about it, maybe September, I want to give 6 month notice, On a normal day, in the formal law, you wouldn't have been able to do that. But now you can do that for September. It can end. So it says here that the tenancy can expire, beyond, it doesn't have to be exactly, sorry. So it doesn't have to be exactly the anniversary. So September now, so 6 months is September 1st, October, November, December, January, February. So it can expire February. It doesn't have to be on the anniversary itself. So there's no way, no minus, or it can even, but of course it's preferable that the person's it expires after the person's rent. Of course you can't say you want the person to leave except you're ready to pay back some part of the money. So you want the person to leave earlier than usual, but I think it's just advisable you allow the person stay to the end and even beyond if the 6 months is not enough. So on a final note, it's very important for us. I noticed that some of these practices of backdating notice to quit, so that we can cover in these 6 months. That's not a good practice, and I've noticed that trend. You want to issue your tenant notice to quit, and you would have written. Maybe this is my own. I'm not calling on anybody because some landlords even issue notice to quit themselves. So I'm not really calling on anybody. I'm only saying that we have to just ensure that if you're giving a notice, let it be complete in the entirety. Not you saying that you're giving a 6 month notice and that you're writing, then the date is not. You give someone a 6 month notice and you don't bring it until December, but you write September on the date. That's and it's supposed to expire by February. That is totally unacceptable, and that's going to be invalid. So you may feel that the date. I'm sure the plan of the person is to prove that the date, but that's not about it. And the person may even tend to lie and say that is a tenant that has been avoiding service, and so when he's finally able to serve. But those things are bad practice. So in all, what am I saying? Tenancy agreement is important for you to have. It's important that you read through all the provisions. So those things really have a long way to protecting you. So for areas that do not have tenancy agreement, or sorry, that this law does not apply to, as we said earlier in the previous videos, they know that they have bargaining power, they know how to handle themselves. And most of these, I've handled one at Ikoyi, and the tenant got 1 month notice because of course they deal with themselves with tenancy agreement, because there's nothing to bind them and all that, nothing to guide them. So I know some of those things. So the lady got 1 month notice and she left after 1 month. Maybe because of the area, there's really no issue of I'm going to stay beyond my time. She left even before 1 month. And so I guess that's one of the reasons that the law really know that these people can handle themselves. They have more bargaining power. They know how to deal with things by themselves. So, tenancy agreement is very important that you read through it, understand it before appending, because there will not be any excuse to say that I never knew this was in it. How did this happen? So that was it. Thank you.